to be have the liquidation value which has been estimated by it, and it forcefully drag the company into the liquidation. So the IBC is for the resolution and collective decision making process. So it has been proposed in the bill that the dissenting creditor will get whatever is low, so there can be a resolution. Further, in section 30, it has been provided that there will be a monitoring committee, though it is right now there in the very well there in the regulations, just a statutory recognition has been provided to the monitoring committee, nothing more than that. And in which cases do you need it? That condition and the manner shall be specified by the IBBI, which has already been there. And NCLT may give notice to the COC to fix plan defects before rejecting it. A plan has been approved by the COC and submitted to the NCLT. NCLT may find that there are a few defects into it which can be cured, like affidavit is not there, or sometimes performance guarantee has been lapsed. What NCLT may consider to give a notice to the committee of creditor to fix the plan defect and then submit it. So it stop putting that company into the liquidation, and so the resolution can be done. And right now there is, I'm on the bullet number 3, last one. Right now there is no statutory timeline for the NCLT to approve the plan, and it has been now provided that the NCLT has to approve or reject the plan within the 30 days, and if there are delays, the reasons has to be recorded in the writing. So the timeline has been provided to the NCLT to approve the plan or reject the plan. The 30 days has been provided. Section 31. In case of, we have found that many cases, resolution almost done, payment is there. The resolution amount is okay with the creditors, but they are fighting, all the creditors are fighting for the distribution of the amount. Say JP, we have a case in Infratech, the resolution was already done in 2019, but the creditors are fighting for the payment, that I should get this, not that, and all that they are fighting. What it does, that it delays the entire resolution process and create uncertainty to the resolution applicant, that I don't know when my plan will be approved by the NCLT, because there is so much of litigation. However, the resolution applicant has fixed amount. I will pay the X amount only, and that is fixed. That is not being disturbed. So what has been now provided, that on the recommendation of the committee of creditor, NCLT may approve the resolution plan first, after that the distribution, the manner of distribution, and that distribution has to be done in the 30 days. So it will provide certainty to the resolution applicant that his plan will be approved when there is no other kind of litigation. If they are fighting on the manner of litigation, that can be considered later on, and that will be happen on the recommendation of the committee of creditors only. So the approval can be in the parts. The first is resolution, after the distribution. It will maximize the value. When the resolution applicant is factoring that the delay will be there in the approval also, it reduces their amount. But when you know that the plan will be approved, because distribution of the litigation regarding to the distribution can be considered later on, it will improve the plan, and there will be more resolution applicants will be there for the submission of plan. Section 31, this is to facilitate the resolution applicants, since they have observed that the licenses, approval, permits, etc. are not being continued by the central government, state government, authorities and all. It has been, clarification has been provided now. The new section is there now. Licenses, permit, registration, all has to be continued by the central government, state government and all the authorities, and they shall not be suspended or terminated because of the resolution plan. All the rights and the grants and right has to be continued, provided going forward the corporate debtor has complied with the obligation with regard to such rights and grants. So they have to comply going forward, and it has been provided that the central government, all the authorities will continue these permit registration on this, and this is the premise of the resolution is now, because this is the core asset of the company. So that has to be continued. It is to facilitate and clarify to the facilitate the resolution applicants. Clean slate principle, Ghanshyam Das judgment has been now clearly provided that any debt or claim which is not there in the resolution plan will not be there. All will get extinguished, and no proceedings can be continued initiated against the corporate debtor. There cannot be any assessment of the claim after the approval of the plan. What is provided in the resolution plan, that will be there. Otherwise, what is not written, whether you have submitted or not submitted, shall not be there, shall be extinguished. The plan and debts and claims will be will remain to the extent it is provided in the resolution plan, and rest all will get extinguished. And no proceedings can also be initiated or continue against the corporate debtor with regard to the non-payment of such claims, which, because it has not been provided in the resolution plan, it has been clarified. Further, the explanation has also been added that a resolution plan shall be limited to the asset of the corporate debtor only. So you are not allowed to put anything with regard to the extinguishment of the personal guarantees in the resolution plan of the corporate debtor. Plan for the corporate debtor, you are dealing with the asset and the liabilities of the corporate debtor. You are not dealing with the third party liabilities over here. So another bank's right to initiate any proceeding against the corporate debtor or the personal creditor will not be there into the resolution plan of the corporate debtor. And the resolution plan of the corporate debtor cannot extinguish the personal guarantees or the corporate guarantees that has been provided. Further, right of subrogation, if any amount has been paid by the guarantors, they will not have any right to indemnify it to be paid by the corporate debtor. They will not be, a corporate debtor shall not pay any amount. So subrogation right will not be there in the IBC. Clarified that. Then we do have a judgments. A third bullet, sir, regarding the CCI clearance. Right now, we have a provision that all the PRS, prospective resolution applicants, has to submit the CCI, take the CCI clearance and to submit the plan. And it is just wasting of time. We are burdening the CCI also, and also the BRA, because we are going to, because Committee of Creditors is going to approve only one plan. So what has been provided now, only a successful bidder will have the CCI clearance before submitting the plan to the NCLT. So no, all the RAs can submit it, and this will be applicable into very high, big cases. All MSME, they won't be applicable. Very rare cases the CCI clearance is required, and they do their all due diligence that whether they are capable of getting the CCI clearance or not. So only the successful bidder will get the CCI clearance, not before submitting the plan to the NCLT. The IBC is for the resolution, and if the company is viable, there is a prospect to revive the company, so it should be done. What has been provided now, since it is provided under section 33 that when the time limit is over, the plan is not as per the requirement, there has to be mandatory liquidation. What now has been provided in the bill, that on the request of the Committee of Creditors, this 330 days can be extended. NCLT may give the 120 extra days to complete the process. And in case the plan is not as per the requirement, NCLT may restore the process from the bid stage. Suppose that no major compliances has not been done, there is no CCI clearance there. So NCLT what can do? Then restore the process, provided the request has been made by the Committee of Creditors. So entire IBC is for the resolution. I must say that in the resolution, we are getting 32% of the admitted claim average, but in liquidation, it is only 4% right now. So what is there when the company is viable? There is a prospect to revive the company. The resolution should be made. All efforts should be made to dissolve the company. And also, third one, in case the resolution plan is contravened or not implemented, so if it is NCLT find that there is, because applicant has not committed to payments, but the company is still viable. So NCLT may reinstate the resolution process instead of ordering liquidation. And entire these amendments are for to do the resolution instead of mandatory liquidation. When there is a prospect to revive the company and the request has been made by the Committee of Creditors. Another proposals in the liquidation. Some first one is like when there is when the CRP of the COC is admitted, and you find that there is no meaningful assets, so there is no you cannot do any resolution of the company, and then you are putting the company into the liquidation, then going for the early resolution. It takes lot of time, unnecessary expenses are incurred. So has been provided that when there is no meaningful asset, a COC can recommend the direct dissolution. You can close the company without going to the full process of liquidation. And so there is no point of running the liquidation process and going, then you can have the direct dissolution. If there is no meaningful asset, that has to be decided. RP and committee of creditors will mutually decide it how to take it further. And in case, second bullet we are on. Okay. Right now, there is a automatic process. RP will continue as a liquidator. Now, what has been provided that the committee of creditors can consider RP to act as a liquidator, or they may select a different IP as a liquidator. It's the committee of creditors who will decide that the same RP will act as a liquidator, or the different IP can be therefore the liquidator, can act as a liquidator. Decision rests with the committee of creditor. Continue moratorium during resolution and liquidation. Moratorium during the resolution will continue in the liquidation. Now, right now in the liquidation, you cannot start new proceedings, institute any suit or proceeding during the liquidation process. But you can, the old proceedings can be continued, which is unnecessary, taking lot of time of the liquidator to deal with such kind of litigations. Now it has been provided that moratorium, you neither can institute any suits or proceeding nor can continue. And if in case the liquidator wanted, he can do so with the approval of the adjudicating authority. So majorly the moratorium during the resolution will continue in the liquidation. Other person cannot start it. No, even the old suits and proceedings cannot be continued during the liquidation process. Bullet number 4, there have been some common activities like inviting the claim, verifying the claim. So what has been provided that this common activity shall be removed during the liquidation process. The activities which has already been done by the RP during the resolution process need not to be repeated again. That will be removed. The liquidator will directly go with the auction and that issuing an auction notice and auctioning the process. The claim invitation and verification has been removed in the proposed bill. Against bullet number 5, section 35 amendment, that the decision of the committee of creditors shall be binding for the liquidator. So same role of the COC will be there in the liquidation also. And bullet number 6, COC can replace the liquidator. As such, there is no explicit provision under the code. Now it has been provided in the proposed bill. COC can replace the liquidator. There is no statutory timeline in the code for the completion of the liquidation process. The statutory timeline has been provided that the liquidation process should be completed in 180 days, which can be extended by 90 days. And further, as we have discussed, the company can be dissolved pending avoidance transaction, and other proceeding like litigation regarding the distribution can be continued after the dissolution, because there is no need to run the process, incurred expenses during the process because the creditors are fighting for the distribution. So company can be dissolved pending the manner of distribution you are fighting for, creditors are fighting for, which can be educated later on. Clarifications and many changes in the section 52. A secure creditor has to inform the liquidator within the 14 days if they want to realize their security interest. In case the secure creditor is not informing the liquidator in 14 days, then it will be considered as a deemed relinquishment, that the asset will go to the liquidation state provided clearly in the section 52 proposed bill. And in case there are more than one creditor for the security interest, 66% of the secured creditor should agree to realize it. In case the 66% don't agree to realize it, that means it will consider as a relinquishment to the liquidation state. So to realize the asset out of the liquidation state, 66% of the secured creditors should agree to realize it. And third one, though it has been already there in the regulation, now provided that all the secured creditors who are going out of the liquidation state, the liquidation process, and realizing under Section 52 has to share the cost, not only the CRP cost, but the liquidation cost as well as the workman dues, which is there in the regulation now provided in the proposed bill. Section 53, clarification 3, two clarification and illustration added. In Section 53, first explanation provides that secured creditor shall be secured to the extent of value of security interest. So for the remaining, if there is no security interest to the debt, then for the remaining amount, it will be treated as an unsecured creditor. So explanation has been added. That means it is the legislative intent of the court. It's from the inception it was there. So because there is some kind of ambiguities, there has been ILC discussion that it is but obvious the secured creditor will be secure to the extent of security interest, but later on it is recommended to clarification may be provided. Government dues will be remain at the same priority. No, it won't be treated as equal to the financial creditor, whether secured or unsecured. Government dues remain at the same priority. Its explanation has been added. Clarity regarding the interstate priority, that will be honored. First charge holder, second charge holder, all the contracts shall be honored during the under the IBC. Shall I proceed further now for the CIRP?
Yes, please carry on.
Okay. Okay. As we have seen.
Please, like to ask audience that everybody is noting down their question.
Okay.
We shall ask it to her.
Taken. Noted, sir. Thank you, Manojji. As we have seen that there is a fast track resolution provision, a mechanism under the code, but therein only the timelines has been reduced, entire process has been exactly same, but we don't have any case for the fast track resolution. So what the proposed bill seek to omit the fast track resolution process and introduce the new CIRP, creditor initiated insolvency resolution. As its name denotes, the process shall be initiated by the creditor, and what type of creditors can initiate it and the kinds of company it will be applicable, that shall be notified by the central government. So it will, the financial creditors who are financial institutions notified by the central government can initiate it, and the companies on whose companies this process shall be applicable, that also be notified by the central government. I'm taking to you to the flow chart to make this entire process, to understand this entire process roughly. Pre-commencement. So financial creditors notified financial institutions, that means the financial institutions defined under the code and notified by the central government can initiate the process. And you need to have at least 51% of the notified financial institutions. So financial institutions approval is required, consent is required, 51% of the value of their debt. And what they have to do, they have to inform the company that they are going to initiate this process, and they will give the time to the company that within the 13 days they can make any representation. So they will give the time of 30 days to the company to make any representation. The CD may make any representation or may not. What financial institutions will do, they will, after considering the representations made by the company, they will again get a consent of the financial institutions. 51% of the notified financial institutions will consent that they wanted to initiate the process, and then the process will be initiated. An RP shall be appointed, and RP make a public announcement here. A date of public announcement shall be the commencement of the process, the date of the commencement of the process. And that announcement shall be communicated to the NCLT and IBPI. So directly you are going to initiate the process. No need to go to the NCLT for the initiation, because financial institutions having the 51% of the value majority wanted to initiate the process. And post commencement, what will happen? The Management shall be with the board of directors, that the management rests with the company, and RP will attend the meetings with the veto pass. So RP will attend all the major and all the meetings of the board of directors with the veto pass. COC shall take a decision with the 66% as usual. All the COC will supervision of the COC shall be there. Decision making power of the committee of creditors shall be there. And after making the public announcement, the company can object to the NCLT within the 30 days of commencement, or we can say public announcement. And the company can go to the NCLT. What they can say, there is no default and procedure has not been followed. The NCLT will reject will make that entire process void ab initio. But in case there is a default but the procedure has not been followed, what is the procedure? That the pre-commencement, the approval of the 51% of the notified FIs, intimation to the CD, taking their representation, all that procedure has not been followed, but the default has been there. NCLT shall convert the entire process into the CRP. And of course, approval of NCLT will be there. Entire remaining process, you have to invite the bids and resolution plans will be there, and you have to COC shall approve it, and the plan has to be further approved by the NCLT. Section 29 shall be there. And again, this plan shall be binding on all the stakeholders. There will be a clean state principle, 32A protection will be there. In case the CRP can also be withdrawn if 90% of the committee of creditors agree. I am on the last third bullet. If the 90% of the committee of creditors agree, the CRP can be withdrawn. Again, CRP will be converted into the normal CRP process that resolution process we have under the IBC right now. When there is a no plan because default was there is a non-cooperation by the committee, the CD, the CRP can be committed, or the NCLT reject the plan. The process will be committed into resolution process. And the entire process has to be completed into 150 days, and which can be extended by the 45 days. A moratorium will be there. How the moratorium will be applicable? The financial institutions may tell the RP to make an application for the moratorium. Otherwise, CD is cooperating. All the financial institutions are there. There may not be requirement of any moratorium. They find that the moratorium is required, something like for the another creditors, then the application shall be made by the RP to the NCLT, and moratorium will be there on the date of making application. An educating authority has to adjudicate this moratorium application within the 30 days. It can confirm it or reject it. In case it is rejected, the public announcement shall be made that the moratorium has been rejected by the NCLT, and committee of creditors will take the further decision what they will do, convert it into CRP or something else. That's it for the CIRP. So basically, you will see that much time which has been taken in the admission or the non-cooperation by the management is reduced, and you can run the process. But the NCLT approval is required because we need to have the binding on all the stakeholders, and there is a clean state principle also. Genuine defaulters can use this process. Group insolvency. Enabling provision has been there in the group insolvency, and central government has been empowered to issue rules for the coordination and the cooperation among the corporate debtors of the group. What does this mean? Only the insolvent companies of a group will be there. Solvent companies will not be there. We don't come bring the solvent companies into the IBC, whether there is a holding company there in the IBC or the subsidiary company. Only the insolvent companies of the group will be there in the group, and solvent companies will be remain outside. There will be a common educating authority bench for the CD of a group. One bench will be there who will take all the CDs, insolvent companies under it. And there shall be a coordination among the insolvency proceedings, and there will be one common IP, or we can say group IP or a common IP, to coordinate everything. There will be a committee of the all committee of creditors of the group company. That is right now, these provisions has been provided under the proposed bill. Any decision on whether the PA of the ED prevails after the CD is admitted into the Nothing like that. No provision is there. No amendments with regard to 32A. And these are the provision which has been provided right now. Central government will come with the entire rules. We do have the reports regarding the group insolvency. There will be the rules. Post this bill will be issued by the central government about the coordination and the cooperation of the insolvent companies of a group to deal with that. Again, a cross-border insolvency, central government will come up with the rules. What has been provided right now that a class of debtors, here the PG or the companies, will be notified by the central government on whom this cross-border insolvency provision shall be applicable, and there will be a designated one or more benches for all the cross-border insolvencies. So there will be a designated benches. So because it is a different, but the specialized area, so there will be designated benches for the dealing with the cross-border matters, and rules will be formulated by the central government. With regard to PG to CD cases, interim moratorium shall not be applicable to the PG to CD cases. So, an interim moratorium has been removed from all the PG to CD cases. It has been observed that the erstwhile that personal guarantors are misusing it. They are putting the application into it. We have many orders of the educating authority that how this interim moratorium is being used, so that for the personal guarantor cases, interim moratorium shall not be applicable. And the report by the RP during the admission process of the PG to CD resolution, the admission of that PG to CD admission application, the 10 days has been extended to the 21 days. The RP has to submit the report to the educating authority within the 10 days. Now it has been extended to the 21 days. There is some kind of gaps into it with regard to the non-repayment of plan. In case there is no repayment of plan is submitted by the personal guarantor, the application for the bankruptcy can be filed by the debtor or the creditor. So the provision has been now provided. Clarification has been there. That particular provision has been provided because there is a gap. What to do when there is no plan is submitted by the PG? It is mandatory to have the meeting of creditors. Now, for the consideration of plan, it is provided that there has to be a meeting of creditors during the resolution process of the PG to CD. Same provision which is there for the CRP of the CD, trading defrauding creditors, has been provided in the bankruptcy process of the PG to CD. Verbatim, it is exactly the same. It was missing in the bankruptcy process, now has been provided into the bankruptcy process of the PG to CD. Section 178, distribution for waterfall mechanism for the individuals, clarified that is whether the central government, state government dues, any authority dues, secured and unsecured, shall be considered will remain at the same level. Further, the look-back period of the avoidance transaction has been extended. It is from the initiation date. Now, because sometimes admission takes so much of time that the look-back period reduces. So, what has been provided that the look-back period will be seen from the initiation date, that is a date of filing. From there, you have to see the 2 years period. Suppose there is a 2-year period for the related party, and in case and the period after the filing until the admission will also be included into the look back period. So the look back period has been increased now. Penalty for the frivolous and vexatious application. So any application filed during the CRP process or the liquidation process, PG to CD, whatever the application has been filed, so there will be a penalty for the frivolous and vexatious application, which is actually delaying the process and there is no merit in the application. The adjudicating authority can impose the penalty, which can be around from 1 lakh to 2 crores. A has been empowered for such kind of frivolous applications which have been filed to delay the process. And in case the RPO liquidator has not filed the avoidance transaction, creditor, member, any partner of the corporate can file the avoidance transaction. Decriminalizing the section 235A, wherein the special court is empowered to impose the fine if there is any contravention of there's any contravention of the provision of the code, regulations, or the rules. Now, educating authority has been empowered to impose the penalties, provided the application have been filed by either the central government or IPPI. So A has been empowered because A is there and is supervising and sitting over the process, understand the process, and it is required that the immediate action can be taken. Educating authority has been empowered to impose the penalties with regard to any non following adhering the provisions of the code or regulation rules therein. Section 215, CD has been mandated to authenticate the record. They have to respond to the records which has been provided to him for generating the record of default. CD has to do that. In case they are not doing it, it will be considered as a deemed authentication. Now, CD is mandated to do that. It is there in the regulations now provided in the code. There will be a one technology platform for the IBC processes. There will be a Aiipa integrated platform for the IBC ecosystem, wherein all the pillars of the IBC, Educating Authority, NESLIU, IBBI, MCA, portal for the RP will be there. The process will be run on the this online technology. There will be a one entire system will be there for coordinating and integrating the entire processes and the all the there will be one process to integrate all the information to them. One source of information will be there, which will be accessible to everybody, whosoever is eligible to see. There will be one platform will be there, and that enabling provision has been provided in the code for the same. IBBI can levy the fees with regard to the processes under the code. Clarity has been provided, explanation is there. And IBBI to issue standard for the committee of creditors, already issued, guidelines has been issued. Further, it has been provided that on the basis of material available on record, the prima facie opinion is there, IBBI can issue an SCN. With regard to the DC, it has been provided that one or more person, there can be a one-person committee, there can be more than one or two or more person committee can be there. And who can be a member of the DC can be a chairperson, whole-time member, other officer not below the rank of executive director. So there can members can be chairperson, whole-time members, or the executive directors can be the member of the DC. Appeal against the DC order will go to the NCLT. It has been provided, and IBPA can make the regulation for the purposes of the code. For the object of the code, IBPA can make the regulations. Thank you.
Thank you, ma'am. Thank you very much. This has been an extremely elaborate.
ममता जी, आपकी आवाज कट रही है.
This is touched upon. Is it better now? Manoj, you can take it up then. If my
now it's better. You please continue.
Internet is not stable. Ajanta ma'am, for really dissecting it so deeply and also telling us the logic behind each amendment. So that was the beauty of the whole presentation, because once we understand the logic, it just gets inside our head. So thank you so much, ma'am. It also shows and depicts you have dived into it and such thoughtful. It is a great project, actually. It is a very cumbersome and a very wholesome project. Giving a change to an act is not an easy task at all. So I'm sure you'll get a lot of public comments. And may we first also mention that those comments be actually kindly be seen with all seriousness, because sometimes the wordings may not be so appropriate while we give the comments. But if the meaning can be just extracted from there as to where we are coming from.
Definitely, ma'am. Each and every feedback is important to us.
So thanks a ton. Thanks a ton once again.
Thank you so much.
Ma'am, can you stop your sharing of the screen, please?
Yes.
Because now we be on the discussion mode.
Yeah.
Now we be on the discussion mode, please. Thank you very much. Thank you. Now screen look like to be quite enlightened. Okay, now here we have planned in this way that as far as our physical presence is concerned, I be represented by Mr. Kohli, who is just sitting aside with me. Now we have noted down questions which which we be interacting with you only for the reason that instead of interjecting in between, because that generally kills a lot of your precious time, and your precious time is our precious time. And other thing is that before we proceed further, my due apology if I use any hard words in my initial remarks. But we spoke by from our heart. IPA always spoke from our heart. What we in our opinion is the problem of the IPS, or in our opinion is the problem of the IBC, whether it has been taken care in the proposed bill, or what is outside the proposed bill also, that may be taken care either in the bill or otherwise. And I think you will forgive us if you have said anything wrong in my initial comments. Okay,
I didn't
now.
find anything like that, sir. Please. Thank you so much. Hanji,
We
continue,
need
please.
we need to be humble. Okay, continuing your debate discussion on the IBC. Now, Mr. Sharaf, are you there? Mr. Sharaf from Kerala. He's a very renowned advocate from he's Bangalore based. Mr. PT Joy, is he there? Okay, okay. Now I request Mr. Kohli, has been sitting alongside with us, to start deliberating on it. We have noted on a lot of points, and he be asking you all these points. Mr. Kohli, please ask on behalf of everybody sitting here, please.
So thank you very much, Manoj ji and Aipa. And I am representing here Association of Insolvency Professional Entities, being in the capacity of the director. So Ajanta ji, सबसे पहले thank you very much for coming forward for our profession and doing so much. And Ajanta ji, you have been instrumental in these amendments, also bringing these amendments. I have been involved with you since last maybe 2.5 years. So work was going on. So it has come out very nicely. So I will just like to, for the sake of our professionals and whatever I have understood, firstly, I like to just, sum up or give a brief of these amendments. So basically the issues being faced in IBC were the delays. The delays that were the major most issues which all the FCs and all stakeholders have been talking about. Then was litigations, a lot of litigations. Then these three judgments of Supreme Court, Vidarbha, Rainbow, and Prabjit Soni. And then, then for the RP's perspective, there was an issue regarding, a continuation of the proceedings for an immortal time. So, which was mainly, we were not able to file dissolutions due to the pendency of avoidance applications. Then is COC was not, IBBI did not have the power to regulate the COC. So what has been done in these amendments, basically what I see is by means of, bringing in certain amendments about the delays. First is that 14 days period has been fixed for the adjudicating authority. And also to cover up the Vidarbha judgment, the amendment which has been brought in, which is that only default is to be seen by the adjudicating authority. This is very nice, but I will definitely speak what all the issues will be faced. We'll definitely like to discuss with Madam. And then is secondly regarding the delays, the basic thing is this regarding the chances of rectification. See, what used to happen earlier, the adjudicating authority has to simply reject the plan if it is not compliant. So this chance of rectification has been given. Then which COC can rectify. Thirdly, there was a major issue regarding the plan approval continuing for a long immortal time. So which now has been restricted to 30 days. Otherwise, recording of the reasons by the adjudicating authority. And then, there is very nice provision regarding continuation or reinitiation of CRP, or maybe giving another chance, we may say, if at all, due to non-implementation or due to any reasons, the plan is not implemented, the CRP fails to bring in the results, there is an opportunity to, for another chance, though the adjudicating authority.
सर आपको म्यूट है, उसको ऑन कर दीजिए.
Yeah. Yeah. So basically, fine. So basically, earlier the judicial authorities were using their judicial powers to bring in, to giving another chances, as has been done in some other matters. Now, what has happened is then to remove the litigations, which was primarily, firstly, about distribution. There was a, very big issue among the COC members. Now, distribution has been, this was stalling the resolution process. So now the COC, this distribution thing has been separated from approval of plan. So let the plan be approved, the COC, the CD may be revived, and distribution thing may be handled later on, but for which also 30 days time has been fixed, which is a very nice welcome step. So then, this thing, this 28A, this assets of personal guarantors, this I would specifically like to mention, in my own matters, like I discussed with Madam that day, in Dunar Foods and in another matter, Best Foods, what the issue was, the personal guarantor, what they do at the time of mortgage itself, they plan it like this, that some of the land inside the plant, they retain with them. Though it is mortgaged to the bank, but it is in their personal name. They do not purposely buy it in the name of the company. So when the company is being resolved, how the RP can hand over the asset of the personal guarantor. This issue was really disturbing, and Best Food has suffered a lot. I think till now they have not been able to sell the property worth hundreds of crores. So this matter will be resolved. Then, dissenting creditors. This was another very huge issue for litigations. So, dissenting creditors, now there has been there is a provision, though there may be certain voices which may say yes. So how can there some creditors speak about that some creditors may take it on ride that they are in majority and the minority may be suppressed. But in any point of time, the litigation in the broader interest of the IBC and the economy. So somewhere the line has to be drawn. So which has been very beautifully drawn by way of this dissenting creditors to be assigned either the amount which they hold the security interest or whatever is being got in the resolution plan. So nobody can be incentivized for the dissenting. So this was the primary logic, principal logic, very nicely done. So it was the thing which so then then the other thing which has been done is clean slate. There was not anywhere in the code that the liabilities will be extinguished. Only the Ghanshyam Mishra judgment was coming to the rescue. So which has now been codified. So which is also very nice that now there is a more clarity and we can hope for a better value maximization. So and monitoring committee, yeah, definitely it was not there. Then even the COC regulation so we'll come to that COC. So this was also a very huge issue that the COC was not regulated and there was no power with IBBI. So which has been now brought into the code that IBBI can also regulate them too. Like IPs. So this is very nice because that was delaying the process. And believe me, the 40% of the resolution processes, the time consumed is in approvals by the COC members. So that is very welcome thing. Then is direct dissolution. If there are no assets, direct dissolution. This is also very welcome. Unnecessary wastage of time. And the basic thing is the RPs, the liquidators, they were facing the issues that they were unnecessarily being penalized, that when they come to know that the case I have got does not have an asset, so none of the creditor will take the interest, and the professional is the only sufferer, and nobody is going to pay him his fees, or even for that matter the expenses he has to incur, because he has to do the compliances by since it is put upon him by the code. So that is there. Then also the invitation of claim process, this is a very drastic amendment, that there is no requirement now for verification or even invitation of the claims in liquidation, the same COC to continue as in the CRP process. This is huge step, because in liquidation what we used to see was there were certain claims which were much different than what we received in the CRP. So this was another cause of, because a thought process was involved at that time. So by that time they had the thought processes, and these used to be an issue with us. Then RP can be a liquidator. So IBBI has itself, surrendered the, directions given. So that is very nice, that RP can also continue as a liquidator if the COC so resolves. Very nice. Then is claim verification fine, then COC to, then avoidance to can continue after dissolution. Here the question will be there, So it is very welcome step. This was happening because, the COC did not allow the COC, now we can say COC, earlier SCC did not allow the liquidator to assign under 37A or even the 38 thing with distribution among the creditors. They were not allowing. So the liquidator is unnecessarily stuck up in the avoidance, and due to that he was not able to file dissolution. But the question will come is who will handle? So the avoidance transaction post the dissolution process, and who will bear the cost? So as discussed with madam that day, I think these will be covered up in the regulations. So we'll hope that definitely this thing will be covered up, and this is required definitely. So and very nice step about relinquishment, that if in 14 days the creditors do not relinquish. I was seeing this in bankruptcy. In one of my bankruptcy process, if the creditor has not taken steps for sale in 30 days, so the relinquishment will automatically be divided, and the asset will come to the will delve into the bankruptcy trustee. So the similar thing has come, which is very welcome, because the creditors, they didn't used to even respond sometimes, and so basically they will later on will take up another stand. So in 14 days it is clear now, if it is not relinquished, they have to it will be deemed to be relinquished to the liquidator. And about the liquidation cost, but their share in workman dues and liquidation cost. So that provision, I think, has been taken up from company law. So where this in SURFACE, this provision was there, and now it has been brought in IBC. This is also welcome, that they have to bear, though there was a regulation 21A, so which was taken care of, but now it has been brought into the code also, and the clarity is there that they have to bear their share of liquidation cost if they do not relinquish. Then is, and basically this is also very big point, in case of consortium assets, the thing was sometimes only the 10% person, he did not use to relinquish, and the 90% have relinquished their asset. So how can the liquidator sell it when one of the creditor, even holding 1%? So now if 66% decide that yes, this is to be relinquished, so the asset will be relinquished to the liquidator, and even 66% have to decide not to realize by themselves. So that is another thing, that is another good step, that they have 66% have to go under 52, exercise the option. So this is very well. Then is priority of charges. There is another issue, but to some extent it has been covered by saying that the security interest held by them, they will be secured to that extent only. So what used to happen? What used to happen? Sorry. So what used to happen was, this what the thing, the practice going on was, I was sorry, because of that, a little missed it. So basically, what provision has been brought into this aspect is that security interest held by them, only to that extent they will be treated as secured creditor. And earlier, they were secured only for the stock, and other lenders had that the security of the properties, immovable, the real assets. But just because they were sometimes holding the security of the stocks, which is not at all existent as on date, so they were being treated as secured creditor and getting the benefit out of that. So this thing they won't be able to do now. So basically, so this is very welcome. Then is government dues, another. That's Rainbow Judgment and Prabjit Singh Soni, the biggest disaster in IBC. So basically, so now that has been very nicely, been rectified by saying that definition of security interest will be only to the extent, there is an instrument there for creation of the security interest, and not by operation of law. So they won't be treated as secured creditor by operation of any law for that matter. So that is also very welcome. So group insolvency cross border, we have to see the rules. So as soon they come, we will definitely be able to, that is itself. Yeah. So there are 2-3 things, which I wanted to just say. So, so basically, my concern was, there is one amendment which you should, because it is in select committee, there is one amendment which is proceedings against RP for not filing avoidance application. Basically, we were discussing this. Avoidance should be filed only and only if there is a substance. Now, with this kind of provisions, that there will be proceedings against the RP for not filing the avoidance application, it may really be a position wherein unnecessary applications will come in for avoidance, because the RP.
Ideally, sir, actually, creditor member should inform you there
Yes.
is a avoidance transaction. It is not directly they are filing it. In case they inform you in the meeting there is a avoidance transaction, you please file it. Then only they should file it. It is not that they are filing before you.
Okay.
No. You have avoided. They are informed in the meeting that there is avoidance transaction, sir. But being a RP, sometimes you are not filing it. Only then they will file it. It is not like before you file before you they went into the court and filing it. No, they will tell you in the meeting and get it said, file it. But in case then you are not filing because they believe that there is a avoidance transaction, then only the repercussion will be there, sir. Otherwise, no. It
So
is a
for
duty of
deliberate.
always RP and liquidator. Never
Okay.
ever that.
So for deliberate,
Ah.
this thing avoidance, if it's not filed, then only there
Then
will be
only,
proceedings.
because
Then
they're
only.
informing you, please file it.
As far as
We have
PF,
cases, sir. We do have cases when
I
creditors
understand.
are telling to RP,
There may
please
be,
file
yeah,
it.
yeah, I
I
can
know.
understand. I understand.
That
So
cases. And
PF,
they are important, sir. If you're not filing any transaction to the against the directors,
no,
wrongdoers,
that is
then
very,
you are actually disturbing the entire ecosystem.
I
When
can
something
understand.
is there, it may take time to get it done, to get it reversed and all, but you cannot get them free because not filing it. They
Very,
have their own
very right.
repercussions. Yes, avoidance transaction have been filed against that director, that promoter, that person later on. That's
No,
it.
now it's clear. Yeah, definitely.
No,
And
nothing directly to you, sir. Never ever.
okay, thank you. So PF ESI, yeah, definitely maybe because of emotional issue of workmen, it has not been addressed in the amendments. Then home buyers as FCs, which is creating a huge issues. That also same I can understand. It is an emotional aspect or social impacts, that may have been considered by the government for these issues. Then 14 days is too less of a time. I definitely this will be, somehow in my understanding, there will be certain directions, or like it is directive, because there is an application, then reply, then rejoinder, then arguments. This process, they won't be at any cost, they won't be able to complete it in 14 days. there will be certain issues in this regards, though it
Sir,
is very
very
welcome.
informally, I want to share here. Informally, please don't. It is my personal opinion, not IBVA opinion. Huh? First of all, how about it? Like you allow this company management, promoters, director to file a reply to Section 7 or this application, but they have not given you financial statement. They have not filed it. Still, we are allowing that person to litigate. Why not? The opportunity of being heard only when they have tell that to the NCLT that I have done my all work. I'm a genuine person standing in before you. Why we give room to this all this person? Now after they are litigating for 6 months, and then you RPs come to us that there is no financial statements, there is nothing like that, there is no record, there is no accounts has been maintained. Why not think about it? Why not the opportunity of being heard given to only that promoter director who has come with clean hands? Think about it. It's my personal opinion to
No,
go
it's
forward
very
like
nice
that.
opinion, but madam, the only thing which it comes from is principles of natural justice. So I can understand this will definitely happen in.
बता तो रखिए भैया ठीक है PNG will be there. This is principle of natural justice, but
Yeah.
please mention it whether you have filed the finance, you have done your compliances or
Yeah,
not
that
during your tenure.
we were discussing. You will bring take
हाँ,
care in the
You think
regulation.
about that, no?
Yeah, that will be very nice step. That would also be very nice. Then
And
is
once we have an integrated platform, some kind of things, if the financial institutions record of default, because they are genuine, sir, financial institutions record of default, it is not faulty, and they are regulated by the RPI, so they have the substantial amount if they're coming with that the company is actually big and they are the people telling the company is not up to the mark, should be dragged into the insolvency. Their application ought to be admitted in 14 days. The time you are going, if I mention 30 days, another person will come, it should be 60. Another person will say it should be 90. There is no end to it. Idea is to do it as soon as possible.
And the last issue, madam, only thing, like IBBI is very nicely covered up that High Court judgments for disciplinary proceedings by codifying the SCN and all that things. Only thing which is we would request for to be addressed is suspension of the AFA on issuance of SCN. So because it has been many times requested that issuance of SCN, it should not be suspended. It should be only on when the default is proved, in all the laws this is like. So that has not been addressed. So this is the only thing. So
All from me.
Any
Thank
other
you
issue? Any
very much.
questions, sir?
Yeah, Mamta ji, please take care
Yes,
for
sir.
all the online people now, and take care for the chat
Yes.
box also, because I'm taking
Yes,
care of the physical, and we
Yeah,
consumed a
that's
lot
okay.
of time in all these
Yeah.
questions. Please.
There are no chats where questions have come. So, may I request anyone who is appearing through VC mode, if you have any observations to make or any suggestions, please feel free. As Ajanta ma'am has from the front only asked for it. So kind of her. If anything that you have in your mind which you want to speak up, please feel free to talk about it. अरुण जी आपका कुछ क्वेरी था उस समय? I had requested if you can park it and say it again. Yes, Mahendra Prasad ji, thank you. So any other question? Or else then we'll move forward to take up the 3 small discussion notes that has been floated by the insolvency and bankruptcy. Yes, ma'am.
Yeah. Yes, please.
1 minute, sir. Janita ji,
Can
yes.
I leave?
Yes, ma'am. Thank you.
Thank you, Mamta ma'am. Thank you, Manoj
I
sir.
can't stop you.
Why I am here to tell you why I am here, because RP is running the process and it is very important what has been provided in
सेकंड
the
फ्लोर लिफ्ट
proposed
के
bill.
बाजू वाला रूम है 205 203
So it's
हाँ.
very important what has been envisaged in the bill to read in the right manner. Everything is to facilitate the RP to run the process. So it's a RP who is going to run the process. They should know the right spirit of this clauses. That's it. That's why I'm here. Thank you so much, everybody. Thank you, Mamta ma'am.
Ma'am,
And thank you, Manoj. Thank you,
Thank
Aiipa.
you, ma'am. From everybody's
Yeah.
side, only one thing
Yes.
we would like to
Yes,
just sum
please.
up, ma'am.
Yes, please.
Yes. That is, sometimes as RPs, ma'am, you may have also gone behind the reasons why people are not renewing their AFA. Lot of people have actually come from the front and said that AFA एक ऐसी चीज है जो मुझे लेना ही नहीं है. Because sometimes people who are working with all their heart, soul, mind, body, they just get confronted with an untoward SCN, etc., from IBBI. And we are not talking about anything else. I'm sure we all are doing our work, and they feel that they are not rightly heard. And before SCN, if there is some mechanism, because a show cause notice, ma'am, is actually for a professional who are deep rooted in their profession. And ma'am, most of the professionals are seniors. They are
Yes,
20 years
junior,
plus
ma'am.
into the
You are saying this, ma'am. I'm not. I'm very junior to you. Understand, ma'am? You're very senior to me. I'm just.
ना
I'm very
बड़प्पन है
small in
आपने
front
बोल
of you, but I just want to say you, ma'am, first. Whenever any such kind of things are there, when you're conducting process, please have deliberation with the committee of creditors, minutize it.
Hmm.
I do understand it. It is a difficult process. It is not easy. What you are doing is actually very difficult. Taking a company from the management, you don't know what kind of people they are and what kind of resources and the sources and contact they have. Deliberate with the committee of creditors and minutize it. And you know how many complaints we are receiving in a year? Around 1,000 complaints. And action SCN been issued only 50. And after that, 50% are resulting into penalties and all. More than 50%. So, IBP is not taking all the complaints into turning into the SCN. We are very concerned about the RPs and the liquidator and what they are doing. It. That's why I make the presentation, the performance you have done. But deliberation with the
Hmm.
committee of creditors, don't take individual decisions. That's it.
Hmm.
And we will definitely take care about it. It's a difficult process, ma'am. Very difficult
And
process.
ma'am, also one more thing. Thank you for taking cognizance of it. Ma'am, in the implementation period, now we have introduced that a reporting needs to be made to the adjudicating authority by the monitoring committee. In that also, I request that 208 should be made applicable.
You may write to the IBBA,
Because,
ma'am. You write to the IBBA,
yes,
we
yes,
will
ma'am.
consider it.
Sure,
Done.
sure.
Yeah,
Yes.
ma'am,
Thank you so much.
yeah,
Yes,
we be writing to the IBB on behalf of what we have discussed right now. That paper will be prepared by us on behalf of IPA. Mamta ji, me
absolutely.
and you can take lead
Yes,
and
yes, absolutely.
give written submission, because that no doubt what we talked is quite healthy. But when we put something in writing, that has
Yes,
its own force. Say a word is equivalent to thousand, a written word is
yes.
equivalent to thousand spoken word. Mamta ji, I request you for one thing, that we need to deliberate for three things also there.
अजंता जी को फ्री कर देते हैं 1 मिनट. Thank you,
हाँ,
अजंता
Thank
जी.
you, ma'am. Thank you, sir. Thank you, IPA. Thank you, all the artists. Thank you so much. Bye-bye.
thank you. Bye, 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 bye. Okay. Mamta ji, actually, if you can finish all these three within
Yes,
10 minutes, then it's okay. Otherwise, we can keep it in abeyance for the next meeting.
I'll do that. तो last date है for giving.
Okay. You take care of those two. I shall take care for the one. You please carry on. Carry on. Try to finish it within 10 minutes.
Yes, we will just do it in 7-8 minutes.
Yeah, Mr. Sim Prasad has
It's
one question
2-3
to
minutes.
ask. Please. Yeah, please, as quickly as possible. Yes, Mr. Seva Prasad. शिवा जी, आपकी आवाज क्लियर नहीं है. योर वॉइस इज नॉट क्लियर.
What's the end? Take the end.
Okay, Mr. Siva, your voice is not clear. Hence, we can't listen to you and conclude it. We shall take it later on. Please bear with us. Mamta ji, please carry on with your two discussion papers. Mamta ji, your connection is lost, I feel. Yeah, internet is, many times it pinches you when you require it the most. In any case, till Mamtaji come out to be there, let me, I was supposed to take on one amendment which has come out on 30th of August with reference to CPRs. CPRs now, Mamtaji, the moment you come in there, please come forward so that you can take your 2 points. And in that particular amendment, they have said that 30 hours will be CP required by every IP. But against that, they have specified certain percentage whereby that need to be held in a physical manner. I have a great reservation on behalf of IP community that how this physical CPRs will be taken, which is starting 40% in the first year and then 50% and then 60%. Okay. Mamta ji, yeah.
Yes, yes.
Okay, okay. You come back. I thought it get lost. Okay, I have a reservation for that only. And secondly, they have mentioned therein that they will recognize some, some sort of the prisons will be there of recognition that need to be specified so that we IPs can get benefit for that. Mamta ji, now I hand over to you, please. Now you are absolutely visible and clear. Please.
Yes. So since Manoj ji has taken you with the professionals, you may have seen that the credit has been made mandatory. Yes,
Your voice is
Manoj ji, tell me.
breaking. Your voice is breaking in between a
बोलिए
lot.
मनोज जी, you're saying something?
मैं ये कह रहा हूँ आपकी वॉइस बहुत ज्यादा ब्रेक हो रही है, समझ नहीं आ रहा आप क्या बोल रहे हो.
Oh, is it so? अच्छा. अच्छा, अभी is it better now?
Yes, it
Is
is
it
better
better?
now. It is better. It is better. Again, your screen has gone off, and yeah. Please carry on. Carry on.
Yes, I'll just do it hurriedly. So
Yes,
since
please.
Manoj ji has already taken you with the CPR amendments, it will not be an easy task, let me tell you, to do the CPRs coming forward because they have done a lot of changes. They also say that the rolling period of 3 years that was available will now no more be available. अगर आप देखे हैं, so this is
Okay.
what it is, right? See, an insolvency professional is now required to undertake a minimum of 30 credit hours of CP each calendar year. And they say that IPs are exempt from this requirement in the calendar year of their registration. So if you have registered, for example, in June 2025, for example.
Mamta ji, please move forward. Just spend 2 to 3 minutes because everybody physically waiting for the, high tea and all this thing there, please.
Yes, yes. So people who are not there physically, like the credit hours, if you go physically, you'll be able to meet people. If we don't go physically, we miss out on meeting people. So that is what it is. Very quickly, proposed deletion of clause 6 from the code of conduct. Please don't think that the code of conduct has been made easier by deleting something from code of conduct.
No.
Never possible. That is never possible. Deletion of clause 6 from code of conduct has been done
इनको भी ले जाओ.
to tell you that this was already
नहीं, sir,
housed. Manoj, if you can just mute yourself for a moment. Thank you. So this was actually housed already in those particular regulations. Kya tha? What was it all about? In short, if I tell you that it was saying that, say for example, if you're a liquidator in any company, and if you're trying to sell the assets to your relative or the related party, that was barred in the code of conduct. And if you recollect, that was already barred specifically even in the respective regulations. So therefore, they have now said that it need not be there in the code of conduct because it is specifically housed or nested in the specific regulations. So that's the only change that I meant to say when I said deletion of code of conduct. So that's the clause 6 of code of conduct that has been deleted. See, for example, mode of sale. Provided that the liquidator, this is the existing one. And what is the clause 6? Clause 6 is, if you see the top paragraph, current stipulation of clause 6, this clause prohibits an IP or their relatives from knowingly acquiring assets of a debtor. So there the word used is or their relatives. Now, they are saying that it is not required in clause 6 because regulation 33 anyways deals it. So regulation 33 says here, provided that the liquidator shall not sell the assets without prior permission of the adjudicating authority by way of private sale to a related party, his related party, or any professional appointed by him. So you may be missing the word relative because related party definition already includes relative. Similarly, if you see mode of sale given in the bankruptcy process for PG, here also, if you see any professional appointed by the bankruptcy trustee for the bankruptcy process, it's already included. Okay, any creditor already included, and therefore it is not being specifically again given in the code of conduct. So that's the change in the code of conduct. And very quickly here again, review of assignment caps for insolvency professionals. Government, you remember in 2021, June 2021, the assignment caps had already come. I'm sure we are all able to recollect. Now that is now put into the regulation itself. So they say, and also the important change is liquidator was not in liquidation assignment was not being counted, and IRP was not being counted. So in the current change, IRP position, RP position was already there, and the liquidator position. All the three will be counted for the purpose of assignment cap of 10. That's the change. Previously, it was only the RP process. Now they have included liquidator, and they have also included interim resolution professional. All that will be counted. And if you see on top the existing framework, it also had that not more than 3 can have admitted claims exceeding 1,000 crore each. So that's remains. Okay. So therefore, what is the change? Proposed change. To address this, the paper proposes to expand the existing ceiling of 10 assignments to be an aggregate limit that includes roles as an IRP, RP, and liquidator. So the limit is not getting extended, but all the 3 roles are getting extended. And I must tell you what is not getting inside the limit. It is if we are acting as an RP for a PG to CD matter, that is not getting included because they say that this needs more maturity, this process needs more maturity, and they say that we do not prescribe any cap on the number of assignments undertaken through an IPE. So both these two things are not included. What is it that they are doing? If you recollect, previously, clause 22, a clarification had been added in 2021 to bring forward the caps. That will be omitted. And a new, Manoj, I'm just done in 1 minute. And a new regulation, that is 7B, is proposed to get inserted. So that's the change. Okay, thank you so much. So Manoj, we are very deeply grateful to everyone who has joined in and spared their precious time. We are actually very grateful from deep within our hearts to all the organizations who have joined hands, and we are proposing and earnestly requesting that let us come together and actually do more such programs, because it's very important. One thing if we keep on hearing जेंटलमैन बोल रहे थे गुप्ता जी या बोल रहे थे कि भाई एक ही जगह एक ही टॉपिक पे 3-4 प्रोग्राम हो जाता है. I feel that we need to have 7-8 programs because only then it sinks in. Even today when we hear IBC and talk about IBC, we feel, oh, अच्छा ये तो पता नहीं था. So it is important that we keep on talking about it and keep on doing this. So thank you so much. Without much ado, we'll close the program. It is 5:30. We've stretched. I think it was worth it. So Manoj, we meet again with yet another program.
Yeah, I'm
So thank you
really
very
thankful to Mr. R.K. Gupta, who has been a very keen friend of me, and he has been quite constantly interacting on other platforms also. I would request that we have uh, our associations who have been our joint partner in there. If any of their president or secretaries are there, they should come forward. Specifically from Kerala, KIFPF, Mr. Sharaf or Mr. P.D. Joy is there. Please come forward and have few words with us.
Absolutely.
Or from IBC or from NCLT Calcutta Bar Association, or from GIPA or from Hyderabad HIPA, any office bearers there.
Yes, and from NCLT Kolkata Bar Association, I extend all thanks. on behalf of the president.
Okay. I also have a lot of things to say, but what we say that at least when we are deliberating and when we are debating on IBC, we should adhere to the timeline also. And timeline is not allowing me to speak what I want to speak now. Mr. R.K. Gupta, I would request you to give the vote of thanks to everybody by unmuting yourself. And with that, we close our program.
Thank you so much, all the organizers, participants, and Ajanta Gupta ma'am in absentia. Really, all the organizations are doing great work. Let us keep up the spirit and let us be inclusive. Thank you so much. Thank you so much, everyone. I enjoyed every minute of it.
Statement. Thank you, Manojji. Thank you, sir.
With this note, I'm ending the meeting. Thank you very much. Thank you, everybody. Thank you, Mr. Sandeep.